Thank you. Holly's going to record for us. So let me get back. So we are really honored to have our guests and presenters today and have all of you involved. We are CSH, Corporation for Supportive Housing. Our whole focus is on improving the lives of individuals experiencing homelessness or preventing homelessness or helping folks to sustain their housing. That's really what we do. So we do that in 4 ways. We really are a touchstone for collaboration and community partnerships. And we're always looking to advocate for supportive housing. So one of our main focuses is on lending for supportive housing development, but we also do training and education, which this is part of, policy reform, and consulting and technical assistance. So that's really CSH. So now we want to hear a little bit about you. So if you could go ahead and go on chat and just say who you are and what your name, agency, role at your agency is, and what you'd like to learn today. We'd really appreciate that. We will be helping to monitor the chat while our presenters are presenting. So we'd like to kind of hear from you during the session as well. So let's just take a minute and give people a chance to start putting in their introductions. You see Jean is here from WASA. We have Rosianna from SSG, Silver. Icotan. Sounds like people have been on introducing themselves well before I asked for it, so we won't take too much longer, but I'm so glad to see everyone today. So. Okay, let's now turn over to the formal part of our presentation. And I am really thrilled to introduce Patti Prunhuber of Justice and Aging and Alex Flores of the Housing Rights Center. Today, they're going to actually be focusing on emergency rental assistance and other tools to prevent eviction of older adults. We know this is a really timely and important issue right now as some of the moratoriums around evictions are starting to lift, and we want to make sure that all of you are prepared and knowledgeable to help your clients deal with this. So with that, I'll turn it over to Patti and Alex, and they'll tell you a little bit more about themselves and then get started on the presentation.
Thank you, Gretchen. And you can go to the next slide. My name is Patti Prunhuber, and I am a senior housing attorney at Justice and Aging. I'm really thrilled to see the expertise that's in the virtual room today. I feel like you all have a lot to offer to this question and concern about how do we keep older Angelenos and Californians stabilized in their housing? How do we ensure that not a single person gets evicted for non-payment of rent, and hopefully not for other reasons also? That for people who are housing unstable, that we can bring some stability to their situation, and that the pandemic and its economic effects don't further destabilize seniors who are low income, primarily people of color who are feeling the brunt of the economic effects of the pandemic. So a little bit about Justice and Aging. We are a national organization, although we do a lot in California. I've worked with many of you and really value your expertise and your commitment. We use the power of law to fight senior poverty by securing access to healthcare, economic security, which includes housing, and the courts for older adults with limited resources. We focus our efforts on populations that have traditionally been marginalized or excluded, women, people of color, LGBT individuals, and limited English proficient. Next slide. We also have both an internal and an external commitment to diversity, equity, and inclusion. And we think that that's a really core part of our values. And so in all of our work, whether it's housing or homelessness or economic security, we're trying to center equity and ensure that we specifically address the negative effects and the disparate impact that poverty, homelessness, and other issues have on older adults who have been marginalized. Internally, we also are very committed to recruiting, supporting, and retaining a diverse staff and board. And I think that you all know us very well, and many of you have worked with many of my brilliant colleagues. Next slide. I'm going to now give Alex a chance to introduce himself and his wonderful organization.
Hi, everyone. Good afternoon. My name is Alex Flores, and I am the Supervising Attorney at the Housing Rights Center's Eviction Defense Program. So as you might be aware, currently LA County has a stay housed program. It is what we are hoping will be a precursor to getting everyone who is in eviction proceedings an attorney. So currently, the way it works out is 10 different organizations divided by courthouses get funding to represent tenants in eviction cases. And so the Housing Rights Center is one of those organizations. It's a new program for the Housing Rights Center, but the center itself has been around since 1968. And it focuses primarily on supporting and promoting the freedom of individuals to live where they would like, even if they happen to have some sort of disability or face, whatever discrimination may be facing. We do that through counseling, through affirmative litigation, and through investigations to make sure that if a tenant wants to live where they want to live, then they're able to live there, no matter what their sex, race, or disability might be.
I can go over this. It'll just take a moment. So this is what we're going to try to cover today. The eviction process and the protections that exist for tenants. Alex is an expert on this, and he will give you a framework. If you feel like it's confusing, it is, but he can make it clearer than anyone I know. So hang in there and know that he's also telling you that people will get counsel if they are in eviction proceedings. So you don't have to know this, you just need to know it's time to call a lawyer. The impact of COVID, and I guess we'll say the Delta variant on California tenants, both in terms of health and the need for sheltering in place and non-congregate sheltering, but also the economic fallout. What are the federal and state pandemic-related eviction protections? We will focus primarily on the California one. And what are some other tools to prevent evictions? And this last portion is we'll spend a fair amount of time on is what are the rent relief programs, especially the federally funded emergency rental assistance program that California has adopted that provide really substantial relief to tenants who are behind in rent or utilities or even anticipate being behind future rent. Next slide. So I'm going to turn it back over to Alex to lead you through all things housing.
Thank you. Okay, so let's start with looking for rental housing. This is a question that the Housing Rights Center gets quite often, right? This is the first barrier to actually getting someone housed. And it's, I went to apply to this housing and they asked to see this or they asked me about that. Can they do that, right? So the major ones are prior eviction history. So if you have been through an eviction and were actually evicted, this means, you went to trial or you didn't go to trial and that's why you lost. This doesn't mean, there was an eviction filed or something like that, right? This means that a court actually found you guilty and there's some sort of order. That usually can be reported and a landlord can go in and see if that's happened before. The effect would, this kind of goes along with credit history. It's going to show up there, right? And the usual effect is I might not want to rent to you, or I might ask you for a higher security deposit. Prior criminal record sometimes can come into play depending on what type of housing you are trying to apply to. Quite often, if it's some sort of subsidized housing, then they have rules against criminal record. But even those rules, it doesn't mean every sort of crime in your background is going to make you ineligible for that. And then there's other kind of practices that are just discrimination, right? So, asking to see immigration paperwork. Saying, oh, I'm sorry, but we don't take Section 8 here. Stuff like that is discrimination. The Section 8 one is a new one for the state of California, but some of the other ones, right, are disability, religion, national origin, race, age. Next slide. Okay. So what's important to note is what are the protections for California residents? So before the Tenant Protection Act of 2019, it was basically, up to where you lived, right? If you were lucky enough to live in the city of LA in a rent control apartment, then you had protection. If you lived somewhere else, then you pretty much had nothing. So what the Tenant Protection Act does is once you have lived in a place for 12 months, and that place is at least 15 years old, you get some protections. You get protections against rent increases, you get protections against what are the rules that they can evict you for. So that's one of them. The other one that we'll be talking about is the COVID protections, right? Both statewide and what the local ones look like. Again, the County of LA has its own protections, the city has its own protections, and there's state protections as well. Next slide. Okay. So I wanted to go through the eviction process, and fair warning, it is confusing. It's a long process, but that's really the point, right? The point of this training is not, to make everyone, to bring you up to the level of your typical eviction defense attorney, right? The idea is to make sure that everyone can at least understand, there are 5 steps, there are 5 stages, and that just because your landlord says something to you, texts you something, write something down on a piece of paper, that doesn't mean you have to go tomorrow, right? This is a legal process, right? This isn't the case for other states, but at least in the state of California, a landlord cannot just show up one day and change the locks and say, sorry, you're out, right? That is not allowed in the state of California. So that's the most important thing to take away from today. We get so many calls from tenants that say, my landlord just dropped by and he said I have 2 weeks to move, right? Is that true, right? And the reality is, you can't stop a landlord from saying what they're going to say or writing down what they're going to write down. But at the end of the day, this is a legal process. There are, 5 stages. It takes a while to get through, so you have some time, right? Don't move out, stay in there, get yourself to a legal representative, and we'll be able to help you out. Next slide. Okay. So just a couple things regarding what to do if you're served with the notice, right? So the first thing that we have to remember is that it has to be in writing, right? Very often, either landlords don't know or don't care, but a notice for eviction has to be in writing. So if someone talks to you and says, hey, my landlord told me this, that's nice, but it has to be in writing, right? If you do receive anything in writing, make sure to read all papers promptly. If you can't understand them, sometimes they are, easier to understand than other times. Sometimes they're complete legalese and, it's hard to understand. Or if they're in a language that, you can't understand very well, try and get someone to translate that for you. Make sure that if you, just as a general rule, but especially when you receive a notice, make sure every communication is in writing with the landlord. And writing is, the term writing is very wide, right? It doesn't mean a certified letter. It means literally anything that has been written out, right? That has been typed out. So, a text, an email, avoid, any sort of in-person conversation. And I just saw a question pop out. LL is landlord. Sorry about that. Try to resolve the issue if you get a notice. And this depends on the situation. Every situation is different. This depends on the relationship you have with the landlord, right? If it's something that is a miscommunication and you feel comfortable saying, hey, this is what happened, can we resolve this? Or you feel comfortable, reaching out to a friend who can be that go-between, that's fine. Some situations can't be resolved, right? Some situations, there's been a breakdown in the relationship and that's not possible, right? But try if you can, and always keep it in writing. And then the last one is seek legal help for your eviction. That's the most important part, trying to get a lawyer to represent you. Okay, so the next part is it's important to be able to distinguish between three different things, right? So a notice given by a landlord saying that they are terminating the tenancy, right? So you have 3 days to move, you have 30 days to move, whatever it might be. A one-page notice from the court saying, hey, I think you've been sued, you should probably do something about it. And an actual full packet that looks like court paperwork, that says complaint, that says summons, that is the actual lawsuit, right? So that is what triggers the 5 days to respond and all that. So this goes back to, this is a whole legal process, right? They can't just lock you out. A tenant has 5 days to answer. So just make sure that once they receive that summons and complaint, that full packet, that's when the 5 days start. And you don't count either holidays or weekends for those 5 days. So that's when you make sure, you want to answer, you want to get an attorney or get to a self-help center to be able to answer your eviction. Okay, next slide. Okay. So this looks confusing and daunting, and it is. But again, the point is that it is for everybody, right? It is just as confusing and daunting for landlords and for landlords' attorneys, right? And so when someone comes to you and says, hey, I got this notice, does it really mean I have to leave tomorrow, right? Chances are no, right? If you look here at the eviction process, on that very top, it's the notice, right? And it says 3, 30, 60, 90, 120, because the type of notice depends on a whole bunch of rules, right? It depends on where you live, what type of protections you have, what type of housing you have, right? So that's why you need to talk to a legal representative to see if you were given the correct notice or not. So only after that notice expires, that's when they can file an eviction, right? So as soon as that second one, summons and complaint, as soon as that gets served, that's when you have 5 days to answer. Typically, it'll take about 1 to 2 weeks for you to get a trial notice. And the trial notice says, this is the case that you're involved in. You have a trial date in about 1 or 2 weeks from today. With the pandemic, that has slowed. There's really no telling how quickly these trial dates are coming up because the courts are backlogged. And so when you do get to court, there are 3 things that usually happens, right? There's a dismissal because there's some sort of agreement made. There's a settlement where the tenant either gets to stay or they say, okay, I'm gonna go, but I'm not gonna pay you what I owe. I'm gonna get some time to leave and my record's gonna get sealed. Or it's trial, where both sides get to present their case and a judge or a jury decides what's gonna happen. Again, this is a lot, right? No one is expected to kind of remember the ins and outs of the entire process. What's important, again, is that there is a process, right? And it's complicated. And, throughout this whole thing, attorneys do discovery, they file motions. So it's like it's a real life case that takes a while, right, to resolve. And so tenants don't have to worry about it, happening overnight or being locked up by the sheriff overnight. So when you do get to that trial, it's being able to defend, right, what the allegations are. Either, it's not true or I don't owe that much rent because, right? When you get down here to the sheriff's lockout, that is when a tenant either does not answer and they lose because they never answered, or they lose at trial, right? At that point, the sheriff puts a notice on the door saying you have 5 days to move. Even there, however, depending on the facts, there is something that an eviction defense attorney would be able to help you with. So, even if a tenant gets, it's usually like a half sheet, red and black ink saying, this is the sheriff, you have 5 days, refer them to one of the organizations. There's almost always something we can do. Next. So these are some of the usual defenses, right? Again, not expected to remember all of these, but if you do see someone come to you with a notice or ask you about a notice, again, the first thing is it written, right? If it was just verbal, it doesn't count. The other things you want to kind of look at, it depends on what the notice is for, right? If they're asking to pay rent, some of the usual questions is, well, is that the rent that you owe, right? Are they charging you more? Are they adding late fees, right? It's only supposed to be rent. Is the rent not due yet, right? Have they not told you how to pay? Things like that, right? The other type of notices is you failed to do something, right? You are subleasing, you brought in a dog without permission. Again, you want to make sure those are in writing. You want to make sure that there's enough information for the tenant to defend themselves. Next slide.
Alex, before I start, I think you've got some questions in the chat. One is about the fee waiver, and the other is about late fees. Do you want to take those now?
Yeah, we can take those now.
Sure.
Okay. Yeah, so the first one, let's see. So regarding late fees, yeah, so late fees are not allowed. Well, okay, so if a landlord is asking for rent, then they may only ask for rent. No utilities, no late fees, no nothing else. If a landlord wants to ask for late fees, what they would have to do is, instead of serving a non-payment of rent, they would have to serve you are violating the contract notice, right? And have to prove, we have a contract where it stated that you would pay, $25 late fee. You haven't done this on this date, you're violating the contract. But if it's a straight non-payment of rent, it could only be rent. And then for the fee waiver, the question is, if a tenant isn't aware of the fact that they may be eligible for a fee waiver for filing their paperwork and pay that fee, can they go back later and get refunded? I don't believe so. The court, does not like to do that. They operate off fees. We have tried as attorneys to do that and make the argument, well, these fees were paid, but, they weren't represented, they now are, and they qualify. It's been an uphill battle, so I don't think so. I would recommend always applying for a fee waiver. The worst case that could happen, so usually what happens is the court won't flat out deny it. What they will do is they will give you a notice saying, hey, I'm thinking of denying it, and this is why. If you want to fight this, if you want to explain yourself, here's how you can do it. Here's a form you can file. So you get a chance to say, this is why I need help. Seeing if there's any other questions.
I think I answered one of them in the chat. You'll all be getting a PDF of this training presentation with the slides. So I'm going to start talking about sort of some context for why people are falling behind in their rent. I'm sure this is not news to you, but California has, as you know, extremely unaffordable rents, and for low income people, it is often they are very rent burdened, which means the percentage of people who pay at least 30% of their income for rent are considered cost burdened, and the percentage of people who are paying at least 50%, or actually over 50% of their income for rent. And as you can see from this chart, while there are rent burdens across different income groups, the extremely low income, which is 0 to 30% of area median income, which in Los Angeles is about $25,000, $26,000 for an individual. And we know that so many people have less than half that, that 86% of extremely low income renters are cost burdened. And that is for all ages, not just older adults. In general, older adults are more likely to be rental cost burdened and severely cost burdened. And it's not because their rent is higher, it's because their income is lower than the general population. Next slide. And that was all before COVID. And we know that many tenants were already struggling to make their rent payments, and that there is a severe shortage of affordable housing and other costs that people are trying to meet their basic needs. But with COVID, we had, I think, an exacerbation of those factors partly because many people lost their jobs, and there's sort of this idea that older adults aren't working, but many are. They use, part-time jobs to supplement their income, and they also live in households where somebody else in their household lost their job, and the number of people who have lost jobs is not even across racial and ethnic groups, where Black and Latinx households tend to have had a more severe economic disruption from COVID. We also know that there's, a public health concern that if you're evicted, if you have to move or double up or enter or remain in a congregate shelter, it is particularly dangerous in terms of the spread of COVID and the Delta variant. On that note, just today, the White House announced that the payments for shelter, for non-congregate shelter, the FEMA reimbursement of 100% are going to continue through December of 2021 because of the surge in the virus and the fact that it's so highly contagious, even more so than COVID-19. So these figures are from June, but about 6.5 million households in the US were behind on their rent. A larger group were lacking confidence that they could make their next rent payment, and that there is a greater percentage or proportion of Black, Latinx, and immigrant households that are behind in their rent. Next slide. So we've had so many times that we've had to change this slide over the last year because things do keep evolving. But I think I can still say the pandemic-related eviction protections are going to be expiring very soon. The current expiration date for the CDC, the federal eviction moratorium, which is in areas of significant contagion or risk, which right now is over 90% of the country, is through October 3rd. That moratorium has been challenged, but it is in effect on a very temporary basis. Probably more important to our conversation is the California eviction moratorium, which has been extended several times as well, and it is currently extended through September 30th. And the reasoning for that extension, it was going to expire at the end of July, was this emergency rental assistance, all this money that's coming in to save tenancies, to stop this tidal wave of evictions, has not yet had a chance to get out to landlords and tenants and stop these evictions. So we have a very short window. I'm sure Alex is thinking a lot about what the line is going to be like at his door on October 1st, because September 30th is when the California eviction moratorium will end. And so these are evictions that are stayed or not going forward due to non-payment of rent. There are other evictions that are going forward if they allege, health and safety or other tenant compliance issue with the lease. Those are still permitted to go forward. So I think what we want to be sure to look at is there a landlord who sort of tries to do an eviction for non-payment, can't do it, and then comes around with another reason? I guess my answer to that is contact your local legal services provider if you have anyone who is facing an eviction even before September 30th, and certainly after that. Next slide. So what are the protections that we have in California? The legislature passed AB 832, which is what extended the moratorium, and it also provided some other protections for tenants. Remember that Alex talked about, you might get a 3-day notice or a very short notice for non-payment of rent. The AB 832 temporarily, and correct me if I've got this wrong, Alex, changes it so that you have to be given at least 15 days notice. And the purpose of that is to make sure that you have a chance to file the declaration of financial hardship that the landlord is supposed to provide with your eviction. And if you don't get that notice, that declaration of financial hardship form, we have a link here at the end of this training, and you can download it and help clients fill it out. But the landlord is supposed to do that, and that may be a reason to be given additional time. But the key thing is to try to apply for assistance through the California Rental Assistance Program. At the end of this training, you'll also see links to your local, how to find your local rental assistance program. I believe there are 7 different organizations who are operating that in Los Angeles, if not more. There's a whole statewide list, and you can get that that information to apply locally. There's also a statewide way to apply either online or by phone. And for people who don't have access to phones or internet, there is supposed to be a way that you can actually get a printed copy of the application. During the pandemic, there's also, because we're in a state of emergency, and during emergencies, there's often price gouging. There's protection against big rent increases during the pandemic. And there's also, for some tenancies, there's a cap on how much rent can be raised each month or each term. And then if your landlord has a federally backed loan on the property and they've gotten federal relief in the way of not having to make their payments, that also restricts evictions. And then the very good list of standard eviction defenses that Alex went through. We don't want to forget that those are still operating during the pandemic. Next slide. So we mentioned the number of households that are behind in the rent, and we know that that number would be much higher if people didn't do what they could to pay the rent first. As a famous person studying evictions, Matthew Desmond, says, the rent eats first. So people have gone without food or medication, or gone borrowed money, put the debt on their credit card. We have a problem there, which is if they've paid the rent and foregone other things or gone into debt, the rental assistance won't repay that. So there's a lot of money, more than 46 billion in federal emergency rental assistance, and California got slightly over 10% of that, $5.2 billion. And that's just so much money that I want us all to take the kind of no evictions for non-payment in California pledge, because there's no reason for it to happen. The state has a dashboard, and they announced as of yesterday that they had paid out 282 million. In other words, about 6% of the money that they have. So I think that we want to really, I'm sorry, I've got the numbers wrong, but they haven't paid out nearly enough given the size of the funds they have. And so we're going to talk in a minute about how we can help tenants get access to this money. Next slide. So here are the basic eligibility requirements. You have to be obligated to pay rent on a residential dwelling. So if you're in a household that pays rent, you don't have to be the lead tenant. The question has come up, what if you pay sort of a rental payment that's room and board, for instance, at a residential care facility? And in California, the state agency responsible for deciding this has said, yes, that is considered a rent payment. You can use the emergency rental assistance called EARP for that if you meet the other qualifications. So people in board and care, they can use this to pay up their back payments. At least one member of the household qualifies for unemployment or has experienced a COVID-19 related financial hardship. That is to be interpreted very broadly. And I want you to think about, did you have to pay to get your medications delivered? Did you lose access to free food or Meals on Wheels or a meal site because of COVID? Were there things that your daughter used to drop off for you that she can no longer afford to do? Very broadly, I experienced a COVID-related financial hardship. And anyone who is, at 20 or 30% of area median income, at extreme poverty, should be able to establish that quite easily. You can demonstrate a risk of homelessness or housing instability. If you're behind in your rent, you have a risk of housing instability or homelessness. And while the income guidelines go up to at or below 80% of area median income, it is also targeted to people at 50% or below. And I'm going to show you LA's data in a moment, and you'll see that they're doing a pretty good job of doing that. And here's the really important thing. Alex told you all about evictions. You don't have to have gotten an eviction notice from your landlord. You just need to be behind in either rent or utilities, which includes internet, electricity, water. Okay, next slide. So what can you get? This has changed. It used to be, I won't tell you what it used to be, it's confusing. I'll tell you that now you can get 100% of your back rent and your utilities, and potentially also your future payments if it looks like you won't be able to make them. And it's for rent owing from March 1st of 2020 through August 31st, 2021. And I wouldn't be shocked if that August 31st number changes. And that's where the future rent payments come in. That's discretionary with the local agency. And you can get up to 18 total months. So just to give you an idea of the average benefit in Los Angeles, the average household that has been approved for emergency rental assistance has gotten $12,000. Most of it, sent to their landlord, unless it's a utility bill. The payments tend to go directly to the landlord or the utility company, unless the landlord refuses to participate. And we'll talk about that in a moment. Next slide. Okay, so I see Alana has already asked this question, and here's what I think is the answer: is how do you prove financial hardship for older adults who are living on fixed income? I think that you can, think very broadly about, was there any expense or any loss of free access to a service or benefit that the person experienced as a result of COVID? So if they were working part-time and they lost their job or had their hours reduced, if they live in a household where someone else experienced a loss of income, if they had any additional expenses that you can think of, even the expense of taking Lyft or BART to get to the vaccination site, even if they had to buy Tylenol because they spiked a fever after their vaccine. Just think very broadly. And it's just a self-attestation. It's a self-declaration saying, yes, I experienced this. So think very, very liberally on this. Next slide. So our biggest concern is that there's this great amount of money, and it can not just save tenancies, it can actually help people who are experiencing financial distress and might do a lot to pay their rent and forego other needs. It is better for them to fall behind a little in their rent and get this emergency rental assistance payment. but the key is making sure people know about it. And, you know, you are working, many of you work on the ground with people doing direct community-based outreach, and you have to be, you know, the eyes and ears of people needing this, this help. Think about who is at high risk of eviction. Work closely with your local housing advocates like Alex and other legal aid organizations. Make sure tenants know about both the eviction moratoriums and how to complete the declaration form alleging COVID-related financial hardship. And think a lot about how to target your outreach. Are there community groups that you work with that that focus on immigrant communities or language, limited English proficient communities, or disability communities? Make sure that you are partnering with those grassroots organizations so that you can get the word out and perhaps even provide in-person assistance for people who will not be able to navigate this site. There were a lot of initial complaints about how complicated the process was and that it took 3 hours to complete the application. The Business Consumer Services and Housing Agency responsible said they heard that complaint. They simplified the application. They now say it takes under an hour, but it's complicated, and many people will need somebody to guide them through it. And they also need internet access to make it easy and accessible. And there's also how much are local agencies requiring documentation. The rules are very liberal about using self-declarations around income and hardship. And it is up to the local agencies to decide how much documentation and verification they're going to require. They've been encouraged to be very, to streamline the process so that people aren't turned away or unduly delayed due to burdensome verification requirements. And once again, if there's a problem, warm handoff to legal aid. Next slide. Okay. I thought we were going to be a smaller group, and I thought people would, you know, yell out the answer. And if we were in person, I would toss Godiva chocolates, but that's not going to work today. So yes, the emergency rental assistance can help with back utilities, not just rent. This next one, what if a landlord refuses to accept emergency rental assistance? I'm going to explain how the tenant can get the money. Initially, the state said, well, if that happens, you can only get 25% rental assistance, but that has since changed. You can now get 100%. If your landlord won't accept the rental assistance, you can still apply on your own, get the money sent directly to you. You sign a form, a declaration, swearing that you will send the money to the landlord and not keep it unless it's for utilities. Then you send it to utilities. And I thought, Alex, you might want to jump in and talk about what effect a landlord's refusal to accept EARP has on the eviction case, if there is one.
Yeah, so it was not clear before. The new bill has made it a little bit more clear. So now the landlord has to attest that to the best of their knowledge, there is no pending application. They have looked and there's nothing there, or they applied and the tenant refused to you know, do their part and confirm these details. You know, that doesn't necessarily help too much, but what it does is allows defense attorneys to say, oh, you lied, here's the application, here's the approval, you're the one that refused it. What the law also does is currently it allows us to stay a case if we can prove that the money is there, has been approved, but the landlord is the one that is saying, I don't want it. And it also allows a court to say, okay, fine, technically you can win this lawsuit, but you're not going to collect rent from this tenant because you were offered that money and you decided not to take it. I think you're on mute.
And the other thing is that, you know how Alex talked about source of income discrimination. There are also some defense attorneys, tenant attorneys who are arguing that the failure to accept this income is in fact a source of income discrimination that the landlord is engaging in. And so that is another way to bring the court's attention to the fact that the reason this eviction is going forward for non-payment is totally in the hands of the landlord, and she or he could stop it. I thought it might be worth mentioning this decision and ability of all of Los Angeles legal aid organizations and housing rights organizations to join together to provide the legal representation is huge. Generally, 90% of tenants go to court unrepresented, and 90% of landlords go to court represented. And that is a huge imbalance in achieving any kind of equitable result. So the fact that tenants will have representation will really tip the scales of justice. So the most concerning thing now is that tenants will just leave their apartment or default on the housing case rather than trying to fight it. And so that's why it's so important that you all are encouraging people, because you actually often, we don't have a tool, we don't have a way to get the rent paid, but this time we do. And then this final question, I'm going to kick to Alex also, because it's really a court matter of what if the application is pending when the eviction matter comes before the court, but the money has not yet been received by the landlord, and maybe even it hasn't yet been approved.
It's a tricky situation, but what we have been doing in court is proving that there's an application. Usually what happens is you get some sort of like case number, and the landlord gets some sort of notice like, hey, there's an application, here's the number. So the first thing we try and do is talk to the attorneys from the other side and say, hey, is your client willing to take this? If so, let's keep continuing this case until the money comes. That's been our first tool, and for the most part, it's been working. Honestly, I think some of the plaintiff's attorneys are also kind of like, yeah, the landlord's saying no, but why don't we continue it? Because I feel like once the landlord sees a check for the entire amount of rent, it might be a different story. So that's realistically how it's happening right now.
And you got a sort of follow-up question from Evelyn. What if the tenant is already in the eviction process? And I assume you mean, Evelyn, before the tenant applies for emergency rental assistance.
Yeah, so I mean, assuming there's already an eviction and a tenant has yet to apply, there's nothing stopping them. What we do is, and I think what I would encourage everyone else to do is, whether or not there's an eviction, tell people to apply, right? If they are in some way affected by COVID, tell them to apply. If there's already an eviction, if they've already received notice, apply. Because then the worst case scenario is you have, they're able to get to an attorney, and an attorney is telling the other side, wait, the money's coming, hold on, right? And I was going to add one more thing. So the process to actually get that money is, as I think everyone has gathered, isn't exactly the smoothest. And so what we have seen is tenants being able to sometimes cut the line a little bit if they can say, hey, I am in court, in a week from now for COVID rent. Can you help me? And then sometimes, we've seen them kind of skip the line ahead of other people who are not in eviction proceedings.
Next slide. So I think these things as well as we do, that COVID has put enormous stress on low-income renters who were already severely rent burdened. As evictions resume, October 1, emergency rental assistance is a key resource. It can save tenancies and we should use it. And not just for the evictions, as Alex said, anyone who's behind in their rent or is needing some help. It's important that tenants get help accessing this rental assistance and that we connect them with legal services if they are facing an eviction. If you can take those away, that would be great. Next slide. And here are some hot links to resources. I'm going to, Gretchen, if you would let me share my screen. I'm going to try to find for you, let's see if I can, the slide on LA. And there's a great dashboard. Here we go. And let's see if I can put it into, well, let's not worry about the presentation. Let's just look at this. So this is LA by the number. You can see that there have been about 39,000 applications received. And of those, most are complete. And that $455 million has been requested. But right now, the number that have been approved so far is only 12,000 households. But look at that average assistance, over $12,000. So I think this tells us a couple things. It tells us that we've got a lot of applications in the pipeline. The potential to really distribute a lot of money and provide financial relief to many households is huge, and that we're just in the beginning of the process. If you look at the other demographics at the bottom, you'll see that, let me just get rid of this. You'll see that the racial breakdown shows that Black or African American and Hispanic or Latino households are the ones who are qualifying or applying for this in great need, and that matches the Census Pulse data that says they're the ones who are most behind in rent and at risk. If you look at the age group, you'll see that seniors are not doing a very good job of accessing this program. Only 7.6% in the 61, less than 8% total, or not 9%. And in terms of income, as I mentioned, the biggest group are the extremely low income, the 30% of AMI. And this is updated daily, and you can see it for the whole state or for your county. And I'll stop sharing now. And I think that's the end of our presentation. You've asked some really great questions. I always learn a lot by doing this, and thank you for your involvement and attention. And I hope you can take this back and really provide some help to people who are struggling.
Thank you so much, Patti and Alex. Outstanding session. I really appreciate it. We do have a few more minutes, so I'm wondering if there are folks that would like to actually go on audio and ask any questions, or if you're shy, you can put additional questions in the chat. Anything else before, or any observations that anyone has observed working in the system that's doing this?
Yeah, if anybody has experience going through the rental application, the emergency rental assistance application process with a tenant, I would be very interested in hearing what your experience has been.
I,
Yeah,
We have a-
Evelyn?
yes, I would like to ask a question. Are there any agencies around that can assist the elderly with the process? Because, you know, a lot of the elderlies are shut in and some are unfortunately experiencing um, memory loss, dementia, and things of that nature, and they're alone and they have no one to assist them with the process.
Yeah, that's a really big concern. And I think you all might know better the resources, but I would say a couple resources are for people who are in any kind of adult protective services because of a risk of abuse or neglect or self-neglect, that case manager should be able to help them with that process. I would like to say that, you know, the area agencies on aging will pick up this and also help. We didn't mention, and I'm glad it finally came to my mind, this is also available for people who have a subsidy for their portion of the rent. It is not, it's possible to use this for Section 8 or senior housing. And so hopefully their manager could help. Permanent supportive housing, I'm looking to Gretchen and saying, certainly the case managers should be helping people get this rental assistance. So there might be a complex or site-based person who could help, but it's really about getting the word out and then understanding that people will need some you know, actual walking through the application with them and helping fill it out. And if you all want to put in the chat other resources that I'm not aware of, that would be great.
Thank you.
I just wanted to add, I answered a few questions, but I realized I answered directly not to the whole group. So I wanted to just point out, there's a question about what is the cost of an eviction lawsuit for the landlord? It really depends. My understanding is that from you know, the landlord's first call to an attorney through a jury trial, it is anywhere from 5,000 to 7,000 that they would be spending. That's what we think. And then the other thing is how have all these COVID eviction moratoriums, how they affected the court process? In general, all the social distancing rules and all that stuff, the court originally was not the best. And if anyone has been following that, they actually got in trouble and they got fined by the state for not following rules. So that in generally has slowed things down. Also, you know, the more protections, the more confusing it is, because there's a whole bunch of rules. But in general, the more confusion, the better it is for tenants, because tenants attorneys have, you know, much more ability to kind of do something, right? Plaintiffs right now are required to follow all these new rules that they don't really understand, like giving a 15-day notice and giving a declaration. You'll be surprised how many landlords don't do that and just give a simple 3-day notice, or don't give the declaration and simply argue to the court, well, this is confusing, I shouldn't have to do it. And the court's like, yeah, that's not how it works. So that's kind of the effect. It has slowed. But, you know, that doesn't mean that people are not getting evicted, right? Because the court cannot step in to defend anybody. So even if a landlord files a frivolous eviction case, very rarely will the court say, hey, this is not okay, right? Especially if a tenant doesn't answer, they could still get evicted.
Great. You know, there's some chats going on that I think we might want to say out loud. So there was a question about what documents does a person need to gather and upload. And Patty, you responded. Do you want to just say what some of those documents are?
Sure, and again, if you don't have the documents, there are provisions for just attesting to it, self-attestation, and that's really important. But usually there's some proof of tenancy. You don't have to have a lease, but you might have, you know, proof that you paid rent at some point. You might need proof of income, but again, if it's difficult to obtain, you could say what the income is. On the financial hardship or income loss, you can use a self-attestation, but if you have a copy of, you know, your SSI payment or your award letter, or you have someone in your household who's receiving unemployment, remember that unemployment establishes automatically that you have financial hardship. And that's unemployment received during that entire period that you're applying for. So I think that there are different documents depending on the circumstances. But I did want to point out that there's no immigration status requirement. There's no public charge issue for people. It has no effect on food stamps or other benefits. So a lot of that has been kind of taken care of. Alex, are there other documentations that you can think of that come up in this?
Yeah, I would just add, my understanding is the biggest reason that applications get stalled or delayed or denied is that there's no ID provided. So while you don't have to provide kind of any immigration stuff, make sure that they provide some sort of identification. You know, just because they want to see, you know, the biggest issue is like trying to prevent fraud, right? So like that's what slows everything down. So if someone can provide some sort of ID so that you know, like this is a person that's actually applying. The other thing is, especially if someone's in eviction proceedings, one of the documents should be either the notice from the landlord or something from the court saying you're being sued for COVID rent.
Great. Okay. Great. And then I want to ask a really interesting question about what do you think have been the main barriers to getting older adults connected to rental assistance? A little bit broad thinking.
Yeah, there are multiple barriers. I think the first is there's a general sense that I'm responsible for my own rent, and it's my obligation. And I will, you know, go without my medications before I fall behind in my rent. Or I will not have enough food in my refrigerator, but I will pay my rent. So I think there's that. There's also just isolation. There's been tremendous isolation during COVID. And how would an older adult who's falling behind in their rent and a shut-in learn about this? And so there's education and outreach. That's a big piece. And then there's the digital divide and the way in which that makes it very difficult. So we've got a little bit of pride/shame, lack of information, and lack of access as I think the three primary reasons.
That's great. And then we also have a question about whether the process is the same for individuals who already have subsidy, including Section 8 or other third-party programs. You touched on the fact that folks are eligible, but is the process for applying the same, I guess?
Yeah, it is the same. I guess I would just say that landlords can be encouraged to bundle their applications. So if there's a senior housing Section 202 housing complex, and the apartment or the complex manager can look at the rental records and say, gee, I have 25 tenants who have missed a rental payment since March of 2020, and they're behind in their rent. They can apply, with the tenants' cooperation, they can apply for all of those tenants at once, and so that will really help sort of streamline the process. If you have a Section 8, you know, it's probably a landlord who maybe has just one tenant, although they also may have multiple tenants. So that's the way in which it could play out slightly differently. But the other thing is that there is no provision for the rental assistance to pay the housing subsidy portion. It only pays the tenant portion.
Great. There's also an answer that Alex provided about what's needed between March 2020 and August 2020, and then from September 2020 through September 21st. I don't think we've covered that. Alice, do you want to just call out what's required for the different month periods?
Yeah, so again, and this comes out of the kind of patchwork of COVID laws that were passed. But what the end result is if a tenant owes COVID rent, so any rent that became due, and when the law says COVID rent, it refers to any monetary debt under the contract. So utilities, late fees, anything like that. So anything that came due March 1st, 2020 through August 2020, as long as the tenant provides a declaration saying I'm COVID affected, then that turns into consumer debt. So it can't be rent that someone can sue an eviction court for. So that just becomes its own separate thing. But going forward, so September 1st, 2020 through the end of September 2021, a tenant needs to give the declaration and 25% of everything that's due in order to be protected in eviction court based on that COVID rent.
Okay, great. That's an important distinction. We also had a question that you answered in the chat, Alex, about what happens when the rental is sold or property owner wants to move back into the rental property. And also some question about what happens when there's a new owner of an apartment building, what changes? Maybe you could just share a little bit on that.
Yeah. Yeah, so generally, when there's a new owner, nothing really changes. They don't get to kind of start things over, right? So for example, if you live in the city of LA in your rent control, and in July or in June, you get your annual rent increase. And then in August, a new landlord comes in and they go, well, I'm new, so I get my rent increase. That's not how it works, right? If your rent was increased in June, then that new landlord has to wait an entire year to raise your rent, right? So nothing really changes. The only way that there can be any kind of rent increase change is if the landlord asks for permission from the housing department of LA or the county housing department and proves some sort of, I fixed up all these units and now I'm not getting a fair rate of return, right? That's the kind of the legal phrase, fair rate of return. They would have to prove it, and it's a whole thing. And then the tenants get an opportunity to fight back and say, all you did was paint a wall. That's not enough. And then for owner move-in, it depends on where you live for the rules, right? So for the city of LA rent control, it has a long history of this type of eviction, and there's a lot of rules that they have to follow. For the county, and currently because of COVID, it can't happen. You can't evict in the city of LA for what's called a no fault reason, right? Meaning you didn't do anything wrong, I just want to move in. For the county, based on COVID, that used to be the rule, but they just changed it. So the new county rule is, yes, an owner can move in, and there's a whole bunch of rules. One of them is the tenant that you're evicting has to be current in rent and cannot be affected by COVID. you have to have bought this place before this new rule came into effect. And the person that's moving in has to be similarly situated, right? So if the tenant is 65 and has cancer, then you or your mom or your relative, whoever you want to move in, also has to be 65, also has to have cancer. So so it's very strict.
Okay.
I wanted to respond, Gretchen, to Megan's question about
Yes.
if someone has failed to submit the declaration of hardship each month. It's not required that you submit a new declaration each month. You submit a declaration at the point at which you're either applying for this rental assistance and or you're facing eviction. But you don't have to do one for each month. It's cumulative. And there's even, when the law changed, they said the previous declaration is still operative. So they were trying to eliminate unnecessary duplicative verifications.
Great. Thank you. Yeah, that's a really good question. So, okay, well, it looks like we've hit the end of the questions. I want to really thank Patti and Alex again for a great presentation and for all of you being here with us. I hope that you will keep your eyes open for future CSH training with great partners such as Justice and Aging and others. And we wish you the best on your quest to keep folks from eviction. We will be sending out the recording. We'll also be sending out a PDF of the PowerPoint. And we will be sending the links that were in the PowerPoint so that you can access the websites that Patti mentioned. So with that, we'll close out and give you back a few minutes for your day. And we thank you again.
Hi, sorry, could I ask something? Sorry.
Oh, absolutely. Never too late.
Okay, so, and you probably answered this, but I had to take some calls from staff during the training, so I'm so sorry if you did answer. I'm sure you guys have heard of the emergency housing vouchers that are being distributed. And so in the past, we've had the experience of some landlords refusing to work with a third party, which is like Section 8 or anything like that. Is that, I mean, because there's a lot of people that are getting these emergency housing vouchers. So we kind of want to, I would want to kind of preemptively know if that's something that the landlords can just flat out say, no, I won't work with that.
I'll start this and Alex jump in. Your then Senator, now Supervisor, Holly Mitchell, was the author of a very important change to our statute that said that source of income discrimination was unlawful under the Housing and Fair Employment Act. And so if a landlord says, I'm not going to rent to you because you have Section 8 and the rent that is available through Section 8, the fair market rent, meets the asking rent, is at or more than the asking rent, then that would be unlawful discrimination. And the landlord could be sued or compelled to make a different decision. The problem, and right now, because many landlords don't know about this law, they might actually put something like that in an email. So make sure that you send it in an email, don't have a conversation. And it's amazing what landlords will put in an email or a text. But as landlords become more sophisticated, they find other reasons to deny Section 8 tenants that, they might say, I'm not denying them because of the Section 8, I'm denying them because they have a bad credit history or they were evicted in the past. So we'll have to be watching and monitoring how landlords respond to that. But right now, with the lack of great sophistication around that, you often do find landlords actually saying that they're going to do this unlawful thing, which is refuse to take Section 8.
Great. And last but not least, we're getting some requests for Patti and Alex's contact information. I think you're going
It's
to
at
be
the
in
end of the
demand.
slide.
is
We
on-
never got to the end of the slide presentation, but I think it's there.
It is, and it will be, I was just going to say, it will be sent out as part of the PDF that you'll be getting. But I also am glad to do a warm email to Patti and Alex if anyone needs that. So we want to have you all connected. So, okay.
So much.
We're good. Great. Okay, well, thank you all and have a great afternoon.